Rodrigo Roa Duterte, former president of the Philippines, sits at the center of a legal and political storm with few parallels in the nation's history. When the International Criminal Court, ICC, rejected his petition for interim release, the decision did not just keep him in detention. It confirmed a deeper truth: the battle over Duterte's fate is no longer merely about law. It is about sovereignty, power, and the fragile credibility of Philippine institutions. The ICC's rejection was not surprising. Interim release, akin to bail in domestic law, is granted only in exceptional cases. In the history of the ICC, only a handful of political figures, such as Jean-Pierre Bemba of the Democratic Republic of Congo and Laurent Gbagbo of Côte d'Ivoire, have been granted it. And even then, they were released under strict conditions, backed by trusted states that guaranteed compliance. Duterte, by contrast, is no ordinary accused. He is a former president, a political patriarch, and the figurehead of a movement that remains potent and vocal. His camp's messaging since detention, especially his defiant statement, "I did it for my country," has given the ICC every reason to conclude that he remains a high-risk figure, politically powerful, capable of influencing global supporters, and openly hostile to the court. The ICC doesn't just weigh legal documents. It weighs behavior. Under Article 60 of the Rome Statute, interim release is denied if there's a substantial risk the accused will flee, obstruct justice, or endanger the integrity of the proceedings. Duterte's sustained defiance, the messaging from his family, and the capacity of his loyal base to mobilize were strong risk indicators. This is not without precedent. In the case of Jean-Pierre Bemba, interim release was revoked when he was found to be influencing witnesses through intermediaries. Laurent Gbagbo's repeated requests for interim release were initially rejected precisely because of his political influence back home. The ICC learned long ago, when a defendant commands a movement, their words and networks are not neutral, they are power. The Duterte family, including the sitting vice president, has not stayed silent. Their public statements and messages reflect deep concern for the patriarch's fate as his global supporters. For them, speaking out against the ICC is not merely political posturing. It is an instinct born of loyalty to their own. In Filipino culture, where the family is the primary social unit and the defense of one's elders is both a duty and a point of honor, their words carry not just political weight but emotional resonance, as should be. They want their patriarch home, and they are making that known, loudly and persistently. It's easy to forget, the ICC does not have its own police force. It relies on states to execute warrants, arrests, and transfers. The Philippines withdrew from the Rome Statute in 2019, but withdrawal does not extinguish jurisdiction over alleged crimes committed while the country was still a member. The court has the legal right to proceed with the case. Enforcement, however, depends on cooperation, voluntary or otherwise. That is why a new political question has emerged. If President Ferdinand Marcos Jr. formally tells the ICC that the Philippines is willing to take custody of Duterte, would the ICC agree to send him back? The answer is a cautious yes, but only under strict, enforceable conditions. The ICC can authorize interim release or transfer of custody to a state willing to accept and monitor an accused, provided the court trusts the state to enforce its authority. This requires ironclad guarantees. Duterte must not abscond. He must be returned to The Hague when required. He must have limited movement, and the court must have continued access to him. The Philippines, no longer a state party, would need to sign a special cooperation agreement, a memorandum of understanding or binding undertaking, before the chamber even considers it.